Oh, did you get the wrong one?
Did we send these to Pam?
No, I have not.
Okay.
I didn't know what you wanted to do.
Am I supposed to give this to the judge? Separate file, give it to the judge? Thank you. You're welcome.
All rise. This circuit court of Dixon County is now in session. The Honorable Judge David Wolf presiding. All ye have business with this court, draw nigh and ye shall be heard. God bless the United States, this state, and this court. You may be seated.
All right, good morning, everyone. We are ready to...
Recording in progress.
First thing we'll need to do is to consider the request for special jury instructions that have been filed by both sides. The first one that I'll take up is the one that was filed by the defense, and I believe they filed it in regard to the initial charge of the court, and that was the jury charge requested having to do with the fact that in Tennessee, a person cannot be convicted based solely on the uncorroborated extrajudicial confessions or admissions, and it goes on to set out essentially the bishop's standard for corroboration of a confession, including the definition of substantial evidence, prima facie evidence, corpus delicti, and so forth. So, Mr. Lockhart, I'll consider that, and then I'll also consider your request for the Tennessee pattern jury instructions, criminal jury instructions number 42.14 regarding the cause of death. If you would like to address those issues, we'll deal with those first.
Your Honor, in regard to the requested charge on the bishop standard, the only way that a jury will know how to, under the law, evaluate a confession that has been alleged to be false is to follow those rules. In other words, the jury could go back, as the charge is now, and say, well, he confessed to Agent Boyd and Faulkner, and then he told his dad he did it. He told others he did it. He's crying and saying, my dad's going to kill me. Several other extrajudicial statements were made after his confession. And Bishop and other cases make it clear that those extrajudicial statements cannot be considered in regard to whether or not the confession is corroborated. And so that's imperative that the jury know that, so that they'll know how to apply the law and not go back and say, well, he admitted so many times, we think that corroborates the confession. The other request in regard to the corpus delicti is simply what the law is. And then
You're interrupting, I apologize. I'm
Yes,
going to let you finish. In this pattern jury instructions, it talks about, in the second paragraph, The defendant's conduct need not be the sole or immediate cause of death. The acts of two or more persons may work concurrently to proximately cause the death. It goes on to say, however, it's a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of the deceased or another which the defendant in the exercise of ordinary care could not reasonably have anticipated as likely to happen. It goes on to talk about a possible inclusion was if some other circumstance caused the victim's death unrelated to the defendant's actions. That would be a defense to homicide unless the circumstance was the natural result of the defendant's acts. And then it goes on to say, if you find the defendant's act, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, then you must find him not guilty. My question to you is, what proof is there in the record of any other person causing the death? I understand there were implications, inferences, and so forth. I'm asking for you to point to the record as to any other proof of any other person causing the death other than the confession of your client and these other admissions.
Well, first we have an accomplice, a party to the crime, who assisted, according to his testimony.
And who is that?
That would be the 11-year-old older brother to Joe Clyde, Alex Nolan. He is certainly a possibility that can be pointed to. In fact, the state in their interrogation asked questions about whether Alex did this or Crystal did this. So there is certainly circumstantial evidence and some direct evidence. Alex Nolan puts himself at the scene, according to his testimony, of the homicide. And he assists our client, according to his testimony, in that crime. So
he assisted your client, according to his testimony, because your client allegedly threatened to kill him if he didn't, correct? That's what he said.
Yes, Your Honor.
I understand.
Yeah.
Okay.
But if he were charged, he could argue duress, certainly. But that doesn't mean he's not an accomplice. That, if he were charged, a trier of fact would have to make a determination after hearing the evidence. But he is certainly someone we can point to and say that he was there and he had the opportunity and he at least assisted in the commission of this crime. So we think that the state could, the jury could find that. The jury also could find that there's circumstantial evidence that he did, the victim, Joe Clyde Daniels, did go down to the road and he could have been killed by someone in a vehicle. He could have been abducted.
Other than this supposed finding yesterday afternoon of some sort of a car part, which is completely inadmissible in this trial, other than that, what evidence is there that this young man went down and got hit by a car? What evidence would produce for this jury to consider that fact? Other than supposition, inference, and so forth, what evidence was there introduced?
Your Honor, the testimony that a young child is walking on a dark road at night that's been testified to as being a high-traffic road and a shortcut going to and from Humphreys County, that is evidence that would be a reasonable hypothesis. And the jury may reject that as a reasonable hypothesis, but certainly if we're allowed to put on our defense, that's something we should be allowed to argue in this case.
You mean by to argue if you're allowed to put on your defense, meaning, of course, the case is closed. There is
now,
no
putting on a defense under the due process clause includes the trial, the jury instructions, whether or not you get fair jury instructions. I contend that that's all covered under the due process clause until a jury returns a verdict. If the jury comes back in and asks questions, we'll have to address those.
I agree that every defendant is entitled to fair and legal jury instructions. My question, I think, was about your wording about if you're entitled to put on a defense. The case is closed. It's now just going to be argument. The jury's been instructed that arguments of counsel is not evidence. So I'm concerned about misleading the jury into thinking that whatever is said in closing argument should be considered as evidence of the case. You can certainly argue the inferences. You can argue the facts of the case. You can argue what the evidence has shown and how you interpret it, but I'm concerned about this language of this. But I want to let you finish, and then I'll hear from the state. So go ahead.
The other reasonable theory would be that the child was abducted, because the child has not been found anywhere. That is strong circumstantial evidence that the child, when he did go down to the roadway, was abducted. And that would explain the child's body not being present anywhere in this case. The circumstantial evidence is that within minutes, law enforcement arrived after the 911 call, and from that point forward, you've got hundreds of volunteers, you've got officers, you've got helicopters flying over, airplanes with infrared. There's been no proof whatsoever in this case as to our client going somewhere, retrieving a body, and doing something with it. None. It would all require speculation. That is strong evidence that the child was abducted. Because if the child is not here any longer, and there's no proof as to how the child was removed, then abduction is a very likely theory. And I think that also comes under that evidence of someone else. The more important charge that I was addressing was the corpus delicti charge. And the Tennessee Criminal Trial Practice Series by Mark Ward sets out in section 22.7 exactly what the standard is. And so we submit the jury needs to be instructed as to this, because right now, under the instructions as they are, the jury's told nothing about corpus delicti, what has to be proved. The jury needs to be instructed in regard to this, so that they'll understand to meet that corpus delicti, they have to show what's set out in the instruction requirement, and also in the case law that says the death of the human being and the criminal agency in producing that death has to be shown. And it says implicit in that is a requirement that the state prove the death was not occasioned by natural causes, by accident, or by the deceased in person. The most important part of the law in regard to corpus delicti is if the jury finds the evidence is circumstantial only, which we contend in this case it is. There's been no testimony that anyone saw the defendant kill the victim. And there's been no testimony that the victim, when removed from the house, was deceased. We know the defendant's confession that he killed him, put him in a trunk, and took him away. We know that's false. That's been proven in this case. So in order for the jury to understand what law they are to apply to a confession when it's alleged to be false, and also to understand what lie to apply in regard to corpus delicti, and to understand what that means, this has to be charged, because the current instructions would allow the jury to consider additional extrajudicial statements made by our client. They would have no instruction in regard to the fact that in regard to corpus delicti, that the state has to prove that the death was not occasioned by natural causes, by accident, or by the deceased in person. And so we submit we would not get a fair jury trial if a jury is allowed to go back and make a decision in regard to false confession and corpus delicti without being given instructions as to how to apply the law to the evidence in that case.
Thank you. Mr. Crouch, we'll let you argue first in response to his request, and then I'll consider your request.
In response to Mr. Lockhart's request, I'm asking First, that the bishop issue be completely disregarded. I mean, there's no application of the bishop standard to the jury instructions. I mean, that is a sufficiency test required to be undergone by Your Honor. Second, there has been zero proof that the victim in this case was kidnapped, that any of these things which Mr. Lockhart just suggested, there's zero proof of that. I'm going to equate that or relate it to someone arguing for a self-defense instruction. I mean, there would have to be some proof put on that someone acted in self-defense. Now, equating that over to this case, there's been zero proof put on. The defense chose not to put on any proof. None of these witnesses, not one, testified in any way that Joe Clyde Daniels was kidnapped or killed by any other means other than the defendant. Not one. So that request should be denied. And then going into my request for instructions, they were kind of based on whether or not Mr. Lockhart's request would be applied. If they are, the state is requesting that an instruction be provided that it's not the law that the cause of death must be scientifically proven. It's not. And what I mean by scientifically proven is by an autopsy. And two, it's not the law in the state of Tennessee that we are required to produce a body. I mean, someone can be convicted of murder simply by circumstantial evidence alone.
Well, first of all, the request to include in the pattern or in the charge to the jury the so-called bishop standard that's been talked about a great deal in this case is not warranted in this matter as far as this court is concerned. My basis for stating that is the unreported case of State versus Hill from 2017 Court of Criminal Appeals decision, which is cited at 2017 Westlaw 532481. And in that, Justice Montgomery of the Court of Appeals dealt with the very issue that we have here. And that was an argument that the statements of the defendant, which were in that case an admission against interest, were not properly corroborated at trial, and that there should have been an instruction to the jury on the bishop standard. The court dealt with a question of whether or not the modified trustworthiness standard had been met in the case. And it went on to state in the last section of that decision, we conclude that the defendant's statements to Ms. Hallsinger and Mr. Allen were adequately corroborated pursuant to the modified trustworthiness standard. We likewise conclude that no jury instruction was required because whether the statements were adequately corroborated is a question of law for the trial court, not the jury to determine. Likewise, the admissions against interest pattern jury instructions provided by the trial court address the juror's duty to determine whether the defendant made the statements, and if so, to determine the truth of the facts. The defendant is not entitled to relief on this basis. The situation we have is identical in this case. The defendant gave a confession. Whether that confession is or is not true is a matter for the jury to decide, and the pattern jury instructions regarding a confession are included in my draft of the final charge, and I have stated in those instructions that evidence of a confession has been introduced in this case. A confession is a statement by the defendant that he engaged in a conduct which constitutes the crime charged and is an acknowledgement of guilt itself. The court has ruled that the confession is admissible in this evidence, but it is your duty to judge its truth. In so judging, you should consider the circumstances under which the confession was obtained, as well as any evidence which contradicts all or part of the statements made. You must consider all of the statements made by the defendant, whether favorable or unfavorable to him or her, and you must not disregard any of them without good reason. If the evidence in the case leads you to believe that the confession or any part of it is untrue or was never made, you should disregard it or that portion that you do not believe. And it says you are the sole judge of what weight should be given to those portions of the confession which you believe, and you should consider them along with all of the other evidence in the case in determining the guilt or the defendant's guilt or innocence. And in this court's opinion, that jury instruction, which is the pattern jury instruction on confession, meets all of the necessary requirements for ensuring that the jury has the evidence regarding their role in the matter, and that for that reason the request by the defendant to include the definition of the standard that this court had to apply in determining whether or not corroboration of the confession was sufficiently met would be confusing and unwarranted, and for that reason that portion of your request is denied. Regarding your request regarding the corpus delicti, or body of the crime, do I understand correctly that if the state doesn't necessarily oppose the language of corpus delicti, I'm looking at the defendant's request to define corpus delicti and go on to talk about in homicide cases, the corpus delicti consists of two elements and so forth, but if that is included, then you're asking that your instructions be included to sufficiently define it.
Yes, sir.
All right, then I will include the defendant's request starting with corpus delicti, literally means the body of the crime, and conclude the defendant's request as at this paragraph stating in the homicide case corpus delicti consists of two elements. I will likewise include the state's request for definition, for jury instruction rather, and the way I intend to include that is I will state your instruction number 2 first, that the state must prove the death of a human being beyond a reasonable doubt. The state may proffer testimony of an eyewitness to the act or rely purely on circumstantial evidence. The state is not required to recover or produce a body. Having reviewed the case law submitted along with that request, I found that is a legitimate request. Then after that, immediately will state the law does not require the state of Tennessee to scientifically prove the cause of death. Again, having reviewed the case law that was submitted in that request, I found that request to be as well admissible. Ms. Fry will need to make those changes and include that language in the charge. Are you wanting to look at the charge after it is finally prepared before you begin your closing argument?
I would just, we've gotten this far, no hiccups.
Yes, I still need to address the court. The court didn't afford us an opportunity to be heard.
Oh, certainly, yes. Go ahead.
I understand the judicial economy and trying to get it done quick, but we need to address that. Your Honor, the instructions as they are now do not say the state has to produce a body. And the instructions define direct evidence and circumstantial evidence. And the state can argue pursuant to those instructions. There is no jury charge in TPI that says the state doesn't have to prove there's a body. It's a weakness in their case, I understand, and so you would like the jury charge that, but that's not in the pattern jury instructions. The instructions that says to scientifically prove the cause of death, that would lead the jury to believe that proof of death can either be scientifically or otherwise. They've introduced scientific proof in this case, and they've introduced lay witnesses. So in that regard, if that's going to be in there, I would ask that it state the law does not require the state to scientifically or prove by any other means, the body. I would ask the court simply instruct the jury that the state is not required to provide a body or an autopsy report, that they can look at direct and circumstantial evidence in determining if there's been a death. I think that instruction 2 the state must prove the death of a human being beyond a reasonable doubt. That is sufficient. They don't have to be told how the state can do that or what the state can rely on or not rely on. simple statement that the state must prove the death of a human being beyond a reasonable doubt covers it without covering anything else. And the court didn't address our Tennessee pattern jury instruction, which I submit covers this perfectly well. So we don't have to reinvent the wheel on this. The Tennessee pattern jury instruction that is used all the time addresses this. And the pattern jury instruction is given in murder cases, as that is, out of abundance of caution. Is there proof that somebody saw the child abducted? No. But is there proof the defense can argue that something else happened to this child? That's a reasonable theory. Absolutely. And so we contend that rather than reinventing the wheel, use the Tennessee pattern jury instruction we've provided, because it covers all of this.
Thank you. As I stated earlier, I had reviewed the request for jury instructions by both of the parties prior to this hearing this morning, and I have made my ruling, and I stand by that ruling. I think that the inclusion of the corpus delicti is not always included in our jury instructions in a homicide or a murder case. Mr. Lockhart has requested that I include the corpus delicti charge in this charge to this jury. And part of that is that in homicide, it states the following. In homicide cases, the corpus delicti consists of two elements, the death of a human being and criminal agency in producing that death. Implicit in the latter is the requirement that the state prove the death was not occasioned by natural causes, accident, or the deceased in person, or by the deceased in person. And that I'm including, and while he says I did not consider his pattern jury instructions, I did consider them, and I've said I would grant those. But the state's request is also based upon case law that the state of Tennessee recognizes, and those are that the law doesn't require the state of Tennessee to scientifically prove the cause of death. That's absolutely the truth. That is the law in the state. Second instruction, that the state must prove the death of the human being beyond a reasonable doubt. That's part of the corpus delicti. The state may offer testimony of an eyewitness to the act or rely on circumstantial evidence. That's part of the pattern and jury instructions as well. And it goes on to say the state is not required to recover or produce a body. That is clearly the law in the state of Tennessee based on the case law. I think in this case that the evidence is warranted that it does not prevent the defendant from arguing their theories of the case and whether or not they think they can point to any evidence in the case that would support their theory. But my ruling is that those two requests by both the defendant and the state will be included in the final charge. And we're going to make those changes. And other than that, we have prepared a verdict form for the jury's assistance in reaching a verdict because of the multiple counts in the indictment and the multiple lesser included offenses that will take them through each count from greatest to lesser included and assist them in determining how they're to go about their business. I believe that we've prepared that and have submitted that to both counsel for the defense and for the state. So we will take a recess while Ms. Fry prepares the final charge, and then we're going to need to print 16 copies for that. I have advised the jury, and the jury has requested that when I finish the charge, the 4 alternates will be randomly chosen and excused. This is after you've made your closing argument, and I've charged them. The 4 alternates will be randomly chosen and then excused. We're going to load them in a van and head them to Chattanooga. Their request is that their names not be read out loud into this because they don't want to be targeted on social media, and I don't blame them because that's apparently what has happened in this case with other witnesses or other individuals. So for that reason, their names will be not given, but I will use the numbers that they were given or assigned at the time of their jury selection. So I will be randomly picking a disc from this box that will have a number on it. I will read that number out. That person will exit the room and go into the jury room to be escorted to a van to be removed from the courthouse, and their name and address and information will not be admitted or not be published to anyone as far as this court is concerned. They have requested anonymity based upon the fact that everyone's aware of social media is, in this case, they were told this in jury selection, but the social media is in this particular case can have a great benefit to people, but it can also have a negative. And so to protect their privacy, that is what they have requested, and I am agreeing to that. So we will allow them to leave, and then those remaining 12 will then be discharged to begin their deliberations. When they have finished their deliberations, just so everyone understands, they will be they will be loaded on the commercial bus that we had used to transport them up here with their belongings, and they will be escorted back by the Sheriff's Department to Hamilton County, where they will be discharged. So I think that's pretty clear how we're handling it from here on out. So if there are any other questions, we will have this prepared in just a little while and give you a copy of it so that you may begin your closing arguments. We'll stand at recess till that time.
Do you want us to address what we've found in the jury charge that we think needs to be changed or addressed?
Yes, certainly. I thought we were doing that. I apologize. I didn't give you an opportunity to talk about what I had drafted. I only gave you an opportunity to talk about what you were requesting.
On page 2 of the jury instructions, 6 lines down from the top, we would request that after assault, that the court also charge the B misdemeanor offensive contact assault as a lesser included. And Your Honor probably knows that's been charged in all kinds of horrendous crimes, but it's certainly out of the abundance of caution in regard to lesser included. I don't know, do y'all oppose that? State has no opposition.
All right, we'll include it with no opposition.
On page 22.
Well, let me back
Yes,
up.
sir.
That then we would also necessarily include it in count 2.
And all the
which
lesser
is-
included. Yes, Your Honor.
Right, all right.
Yes, Your Honor.
Page 22.
Yes, Your Honor. And it could be that things have changed, but 1, 2, 3, 4 lines down, the defendant is guilty of the lesser included offense of knowing aggravated assault. My understanding is aggravated assault includes knowing, intentional, or reckless. And
He's looking at the first rough draft. That's been taken out.
All right, that's been taken out
Okay.
apparently.
all right.
I don't actually have in my hands the copy that you are referring to. because
Yes, Your Honor.
we've gone through about 3 drafts thus far.
Yes,
Excuse
Your
me.
Honor. And that's all that we've noticed. The state may have noticed something also. Well, maybe not.
Judge, I have already passed up to Ms. Fry in the jury verdict form, voluntary manslaughter, and it says if you find,
Right.
on page 3,
Thank you for pointing that out.
if you find,
We'll take care of that change. That is a typographical error.
We got one change that was submitted last night on aggravated abuse, aggravated child abuse. It should be or instead of and or. Is that-
You made that change.
I put and or.
Yeah. Isn't that correct, Mr. Kendall? I mean, that's what we think, but
So you're saying instead of and/or, it should just be are,
yes,
or,
yes.
We agree.
or as we in the country say, are? All right, then that will be agreed to. Well, all right, then thank you for your input on the charge. We'll make those changes. We'll give you a hard copy to go by. Now, I don't mind giving 1 or 2 for table, but giving a charge for everybody sitting at the table may be a little difficult. So we're going to have 16 for the jurors, 1 for me, and a couple for each of the tables, and that should be sufficient. So we will then stand at recess until such time as we're able to get this ready. So.
All right. This court is in recess.
1500.